everything's negotiable, and then at the end of the lease period, they purchase the property.
Was that usually by the seller or by the lease?
Pardon?
Is the lease purchase usually by the seller or the buyer?
The buyer, lease.
The buyer,
purchase.
okay.
Mutual rescission is we agreed to walk away. And it returns all parties to the original. Buyer's earnest money is returned. It would be acceptable if there are major problems. It would not be acceptable if the buyer decides they don't like the house and want to buy a different property. Once you're under contract, you're under contract. And, you can't terminate the contract just because you get cold feet. A contract is a contract binding upon the parties enforceable in a court of law, period. Once you sign, you're committed. You don't want to close the deal, and it's not subject to a term or condition of the contract not being met, then you're in breach. And you're violating the contract, and now the seller can have legal recourse back against you for breach of contract. Remedies for default, specific performance. And then liquidated damages. Let me explain specific performance to you. It's a double-edged sword. The seller can exercise it or the buyer can exercise it. And this actually happened where my agents called me and I had to throw it out as an option for the buyer. The seller decided a week before closing they didn't want to sell the house anymore. But it wasn't subject to the terms or conditions of the contract, they had all been met. So, the buyer wanted to buy the property, but the seller was like, nah, I've changed my mind. My AD said, what can I do? I said, well, you can terminate the contract under mutual rescission, right? That's one remedy. Or you can file specific performance in a court of law. And here's how that rolls. The judge looks at the contract, says, you know what, all terms and conditions have been met. And under specific performance, orders the seller to settle. Period. That's specific performance. It's a double-edged sword though, because the buyer can pull the same stuff. A week before closing, the buyer goes, you know what? I've changed my mind. I don't wanna buy this house anymore. Well, they wanna terminate the contract, but it's not subject to any of the conditions in the contract. All of them have been met. The inspections, the repairs, the appraisal, the survey, blah, 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 the loan, blah, 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 blah. So there's nothing contractually that gives them the right to terminate the contract. They just get cold feet. Well, the seller can turn around and file in a court of law under specific performance, and the judge will look at the contract, and the evidence that supports that all conditions and terms have been met, ravel their gavel and order the buyer to buy the house. Specific performance. You will perform. Court ordered, judge gotta ravel their gavel. That's specific performance. You understand it's a double-edged sword. Yes?
An example is the buyer had lost her job before closing.
Now I have a condition of the contract, I no longer qualify for a loan. So yeah, no, that's not specific performance, that's a contractual term not being met. Does that make sense?
But that could be a specific performance in a PA.
Pardon?
That could be a specific performance in a, like a contingency.
No,
It's-
you're confusing specific performance as a court action, period. You have to go before a judge. You don't do that with a contract. The terms and conditions of the contract are not met, and the contract says if they're not, then it terminates the contract. That's not specific performance. Those are contractual terms not being met. Completely different.
specific performance only kicks in when all terms and conditions have been met. And now one or the other party changes their mind, you can't do that. And specific performance can be invoked. And the parties are mandated under court order to sign, period. But if you don't agree to affect the repairs that I've requested, and I'm not happy with that, the contract says I can terminate it, because you're not satisfying the condition. That's completely different. The other one is liquidated damages. So here we go, the buyer decides, you know what, I've changed my mind. And I no longer want to buy the house. Now, all the terms and conditions have been met. All the inspections have been performed, all the repairs have been satisfactorily completed. The appraisal, the survey, everything is done contractually correct. And the buyer says, oh, I don't want to buy it anymore. Well, I have specific performance where I have Judge Judy mandate that you close. That's one way I can go. Or the seller can just say, you know what, fine, but you need to compensate me for breach of contract. So we call it liquidated damages. You put down $2,000 earnest deposit. You give me that $2,000, and I'll consider that compensation for breach under liquidated damages. Does this make sense? So you see the difference between liquidated damages, it's another way that we could solve this conundrum, or specific performance, boom, you're ordered. Court orders you. So liquidated damages is kind of mutually agreed to decision, would you agree? But there's a consideration being given to one of the parties, monetary consideration. Not to be confused with specific performance.
Yes, sir. Is the seller with a broker then?
Did the contract close?
No.
So what's the answer?
No.
See how that is?
So the seller can say, I'll keep your earnest money and I want more than the earnest money? Or
Well, they can
just
say
stop?
whatever they want, but typically liquidated damages is compensation for breach of contract. Judy doesn't have anything to do with it, the parties agreed to it. And most often it's the amount of the earnest, or a portion therein. The seller agrees to some form of remuneration.
Typically, the seller has an option to either get the earnest money or sue.
Correct. Well, get compensation, I don't wanna say earnest money, typically that's what I see it as. Or sue under specific performance, now the judge rattles her gavel. Remember, specific performance is a two-sided sword. Two edges, cuts both sides.
So if the seller decides to sue, then they would not be, theoretically, they would not be looking for another buyer.
Correct.
Trying to force this buyer to buy, and they would not look at anyone else making offers for earnest money.
Correct. Because they're still under contract, and they're just waiting for that to be enforced in the court law. Yeah, if they try to take another contract, that's fraud. Yeah, that's a problem.
Well, in the pre-test, there was an answer, because I got it wrong, and it talked about specific performance in a purchase agreement. But you're saying there isn't a specific performance in a purchase agreement.
I'm saying that if all terms and conditions are met in the purchase agreement, and one of the parties wants to walk away, the other party can sue them in a court of law under specific performance. What I've seen as far as language in the purchase agreement is that if a dispute arises out of this contract and is brought to a court of law, like specific performance, the non-prevailing party will pay all costs. Not only their costs for legal representation, court costs, but the prevailing or complainant's cost for lawyers and courts. That's the language I've seen in the PA that we have. Doesn't mean it's not there, you know, I see everything, especially at my age, my eyesight is really gone. I can still see all 6 of my fingers. But that's what makes me unique. Yeah. So you get remedies for default. Specific performance or liquidated damages. Okay, so we just went over contracts. Are we good with contracts? Do we understand the ingredients required? Do we understand the statute of frauds? Do we understand liquidated damages and specific performance? Do we understand unilateral versus bilateral? So I can line through contracts? And by the way, I do appreciate the students that have taken the exam already and tripped on it and are willing to share that knowledge with us. So thank you. Practice of real estate, federal fair housing. Here we go with protected classes. We have 2 laws on the books on a federal level or national level. The first one is the Civil Rights Act of 1866, which says that you cannot discriminate based on race. And it overlays everything, residential, dirt, commercial, whatever. You cannot discriminate based on race. So that was the Civil Rights Act of 1866. It was a way for the government to reconcile and try to resolve their practice of slavery and to give those individuals a right to ownership on anything pretty much. Then we have the Federal Fair Housing Act of 1968 as amended. But hey, we're talking a difference here. And it's in the name, fair housing. So the protected classes that we deal with in federal fair housing only apply to housing. Or if I'm buying a piece of dirt to build a house on it, it comes to bear. But if I just want to buy dirt, nope. I'm not protected under this law. If I want to buy a commercial building, I'm not protected under this law unless race comes to bear, because that's the Civil Rights Act of 1866. So, the Federal Fair Housing Act of 68, as amended, because they massaged this puppy for 20 years. They didn't finally close the book on it until 88. So it ran from 1968 to 1988 before they finally came up with all of the protected classes. Familial status was the last one added in, whether you have children or not. Protects pregnant women and families with children, does not apply to retirement communities. This is a keynote. Remember that if I'm in a retirement community, what defines that is that 80% of the ownership is 55 or older. That's it. Race has been protected since 1866. Sex was added in 74. Handicapped or disability was also added in 88, which includes HIV and AIDS. Alcoholics and drug addicts are protected, but only if they are seeking treatment. And if they're using illegal drugs, no, the protection no longer exists. So if you're a recovering alcoholic or an addict, as long as you're in a treatment program, can't discriminate. Law specifically excludes those convicted of dealing drugs. So if you were a drug dealer, forget it, I don't care if you're in rehab or not. Landlords are not obligated to rent to a person with a history of violence. Both current and recovered mental patients are protected. So if you're a current mental patient, but you're under the doctor's supervision and in a program, you're protected. If you've recovered from a mental illness, but you had one, doesn't matter, you're protected. But if you're mental, and a judge ravels her gavel and says so, let me put it to you this way, you're gonna come across a lot of people that you think are flat out crazy, and that have a mental disorder. But unless a judge ravels their gavel, they're just as sane as you or I. True. So there's a lot of wackos out there and weirdos. We call them Santa Fe's. Anybody here from Santa Fe? Oh, you guys were taking it up in Santa Fe. I thought I was okay with saying that. But you know what I mean. Okay. Let's see, landlords must allow a disabled tenant, this is cool. You cannot discriminate against the paraplegic, quadriplegic, you cannot discriminate against somebody who is physically impaired. And you must allow them the right to modify the residence to accommodate their needs. So if they need to put a ramp on the front, widen the doors, lower the light switches, then you cannot say no. But here's the caveat. They have to do it at their expense, not yours. And the other side of that coin is that when they leave that property, they are, by law, mandated, if required to, put the property back to its original condition. I know property managers out there that deal with physically challenged individuals. We have a lot of former military here. And several of them, many of them are disabled, physically disabled. And they do have to modify their properties, and they do. And when they vacate those properties, I've yet to come across one property manager that has insisted that they take it back to where it was before. And it makes perfect sense economically. The manager is required, as an agency duty back to the owner, to find the highest and best tenant. Well, that means somebody who pays the rent, right? And they know that they are talking to certain demographics. Like if they're dealing around UNM, they're talking to college. Would you agree? Isn't that their demographic for rentals? But if you open the doorway to people that are disabled, is that not also a demographic? And can that not also augment and supplement your efforts to bring in highest and best? Would you agree? I don't know one property manager who has required an individual to take it back to the way it was. And I don't know anybody who has a problem with a light switch being down here or a ramp going up through their door. And especially on a Saturday or Sunday morning, having those rails in the bathroom so they can pull themselves up off the floor. True. So that is one of the things about property management, and you need to understand that you cannot say no, but you don't pay for it. And that when the tenant leaves, they are mandated, you have the right to make them put it back to its original condition, all at their cost, not yours.
What about parking?
What about parking?
Say they move in and there's no parking for them, who pays for that?
They do.
The tenant?
Any improvements to accommodate their needs.
But isn't it an ADA law to have handicap parking?
Then why'd you ask the question?
Yeah, it
Because
is
they
the
let,
law.
because I did the pretest, and the pretest actually said that the landlord had to provide parking, and I was surprised.
Yeah, that's a different law though. You're right, 88. Sir?
So, can I answer that really quick?
Yes, sir.
And, well, this is San Diego County law. I owned a gym. You have to make there has to be a space, so say you have a parking lot and it doesn't have the handicap symbol, then the landlord has to paint a handicap symbol. That's all that means. It doesn't apply to destroying something or creating something that's not there.
And truthfully, with parking and like a fourplex or something like that, I have to bow to the local coding. And local coding will tell me that for every, apartment unit, I have to have 1.5 parking spaces. Or for every toilet, I have to have 2 parking spaces, or however it's written. Truth.
Yeah.
So that's done on a, covenant or a city ordinance, or a county ordinance, or a state ordinance.
All the buildings where it's business down here, residential up here,
Uh-huh.
how are all these tied to that?
The same. Am I renting it?
Be commercial. I don't think the resident's gonna have.
It'll be more commercial.
Yeah. I know that in commercial buildings, we had to put in, when we could, elevators. This building was a good example. This law went into effect though, a while back. And the government gave owners an opportunity to first generate the revenue through income and put that aside to put an elevator in. Until then, they said, hey, look, if you want to, do business, you're on the second floor, you have an office on the second floor, then I have to make a conference room or office available on the first floor for you to affect your business with anybody who has a disability. So there's been workarounds, and we just got our elevator in here. And before that, the owner had to make space available down here.
Thank you.
Color, whether you have color or not. Some mornings you wake up and it's like, whoa, what happened to my color? And the laughing, the knowing laughter. Religion, whether you have it or not, doesn't matter. National origin, I don't care where you came from. Not protected under federal fair housing is age or sexual orientation, marital status, or occupation.
That's what they mean.
Yes, sir.
So, one of the protected classes is sex,
Correct.
and your sexual orientation is.
It is not.
But in New Mexico, it is.
We're not talking New Mexico, we're talking the national exam. Sex, are you male or are you female?
Gender.
Period. No, gender, I've been bid on about gender identity.
Oh, okay, I understand what you're saying.
Sex,
So it's only two.
you're either a male or a female. I can't discriminate against you because you're one or the other. I have a hard time with protected classes. I have an extremely difficult time with the need to even have it. If you're coming into this business with some archaic and asinine ideology that suggests that somebody is less than you, wrong. Go away. You're a lawsuit waiting to happen. I don't care where you were born, what country you come from, what kind of clothes you wear, what you identify with, if you have religion or not, what your gender is. I don't care about any of that. You're a person. You are a human being. It disturbs me that the Civil Rights Act of 1866 says race. If they had simply put the word human in front of that, it would cover everybody. I have buttons, and discrimination is one of them. I will not tolerate it, ever. And I don't want you in this business if you think somebody is not as good as you or equally as bad, they're better than you. Go away. Every person I look at is simply a mirror. You are a reflection of me, as I am a reflection of you. We're all humans. Why would you turn down a potential revenue stream based on something your grandparents or great-grandparents believed in? Which is archaic, it is inane, it is asinine, it is an ideology that you do not need in this location. So I am deeply saddened that we have to have protected classes. I'm deeply saddened that we view each other differently than what we actually are, a reflection of each other, every one of us. Usually I say that for Sunday morning. All right, prohibitive action, steering, blockbusting, and redlining. Are there any questions on discrimination? Are there any questions on protected classes? We will learn tomorrow afternoon when I go over to the state how cool New Mexico is. Because they expanded. It still deeply saddens me that we even have to have it. But yay, New Mexico. Steering, blockbusting, and redlining. Steering. You cannot steer. It is illegal. There are HUD testers out there. Do you know that New Jersey has about 40 or 50 real estate brokers that are currently being sued by the federal government for steering? They were showing properties to whites that they were not showing to blacks. Truth. It's in the news right now. It still exists. Holy macaroni. I was tested by a HUD tester in '02. Gentleman called me and said he was a retired homicide detective with the New York City Police Department. And my immediate knee jerk was he was ex-military, because he told me he wanted to move to Albuquerque. And I know from my experience with the Department of Defense and when I disassociated with them in '85, that the very few people that I told in the military that I was moving to Albuquerque told me that's where they were going to retire. Can you say VA hospital? Can you say PX privileges? Can you say wide open spaces? Very attractive. So I immediately jumped to a conclusion that this gentleman was ex-military. In addition to being a now retired homicide detective for the New York City Police Department. Called me on the phone. But then, he said something to me that was a red flag. He said, Larry, could you help me locate a residence in a low to no crime area? Boom! HUD tester. Immediately. He was asking me to steer him. Illegal. So you know what my response was? I said, sir, it is illegal for me to suggest anything like that to you. However, if you go to my webpage and check my links page, you will find a link to the local police department. And they have that kind of information available for you to research at your convenience. Oh, okay, good to know. Well, thank you very much. You think I ever heard from him again? No. Do you know that they nailed all these brokers in New Jersey with mixed race couples? Do you know that they nailed all these brokers in New Jersey with both black and white prospective buyers? How stupid are the brokers in New Jersey? And they're now being prosecuted by the DOJ, Department of Justice. Do you think they have a leg to stand on? What I'm trying to tell you is this is good to know for test purposes, but I'm here to tell you that you will be tested. You will. And if you don't know these laws and or violate them, you'll be working for somebody else. So steering, verboten, blockbusting. Remember Archie Bunker? Anybody? I loved it. Jeffersons are moving in, right? And there's a real estate agent on Archie's front doorstep trying to tell Archie that he needs to sell now before the value of his property goes down because of the black couple moving in next door. That's blockbusting. It is highly illegal. And by the way, mixed cultures actually give value to property. It doesn't take away. It's actually a good thing. So you understand blockbusting, illegal. Redlining, I get a kick out of redlining. Did you know that our government was guilty of redlining?
Oh, yeah.
Up until the 70s when this law finally kicked in. It was the FHA. The Federal Housing Authority would not underwrite loans in certain areas of town that were redlined as high crime areas or not enough money. Demographics didn't support the money. The FHA, our own government, did redlining. Illegal. So you understand what redlining is? I don't care where you live.
It was huge in Chicago and Detroit where they were
Yes,
not writing loans to blacks in certain neighborhoods.
certain neighborhoods because of the crime stats and the income levels. That's redlining. It is illegal. And they don't do it anymore. They don't do blockbusting anymore. I don't know anybody stupid enough to go out and suggest that just because a different culture is moving in on the street, that suddenly your values are going to go down. That's asinine. And, yeah, steering. Guys, you will be tested. HUD has a very, very deep staff of individuals. And this is nationwide. It's not just New Jersey. I'm telling you the truth, when I got a call in '02, now I have no idea where this guy was. He might have been in California, he might have been in Texas, he might have been in Illinois, he might have been in Maine, he might have been in Florida. I have no idea. But I do know what he represented to me and what he asked of me. He was a HUD tester. They are out there, they will test you. So again, I go back to my basic. If you're prejudiced, go away. Your lawsuit waiting to happen. You represent me out there. Once you get licensed and start working, you're representing me because I'm part of your community. So please don't. Exceptions. There are no exceptions in regard to racial discrimination. Can you say Civil Rights Act of 1866? It is not a violation to discriminate against other protected classifications in the following situations. rental or sale of a single-family home with no broker involvement, because once you bring a broker in, you have to ensure they adhere to the laws. But if you're for sale by owner, and you don't wanna sell your house to me, cause you don't like individuals with goatees, fine, you can discriminate against me. Rental units, 4 units or less, and the owner has to occupy one of the units. Under FHA and VA, you can get a loan on a single-family residence out to a 4-plex, based on the predication that you're gonna live in one of those units. So up to a 4-plex, so it's covered. But it's an exception, because if I, the owner of the 4-plex and living in one of the units, don't want to sell my 4-plex to you because I don't like your sweater or the way you do your hair or whatever stupid ideology I'm working on, I can still be discriminatory. I bring a broker into the equation, boom, I must adhere to all federal, state, county, and municipal laws, and there are no exceptions, and whatever is the strictest always rules. Nonprofit organization can restrict to members only. Rental or sale of units and buildings with at least, remember the 80% 55 and older, they can discriminate because it's a retirement community. And the only thing they can discriminate against is familial status. That would be families with children, because that's what they're trying to get away from. Complaints, HUD will first investigate all incidents, complaints filed with HUD within a year. That's a test question. How long do you have to file from an act of discrimination with HUD? Is the answer to the national question. Aggrieved party can file a civil suit in federal court within 2 years. Do I have to go to HUD first? No. Could I sue you right away? Oh, okay, it's 13 months after the alleged discriminatory act. Can I still file with HUD? No. Can I still sue you in a court? Yes. A broker could file a complaint and request the commission as damages if the seller refuses to accept an offer from a protected class. Again, you bring in a broker into the equation, you adhere to the laws, you violate the law, the broker can sue you. Broker's best protection is to keep good records. When advertising, it's best to describe the property, not who should live there. In a complaint, HUD will consider the following: testing studies done, the property shown, if an equal opportunity poster is in place. HUD will not consider the broker's intentions even if they felt they were working in the buyer's best interest, showing with neighborhoods with children to a family. Oh, I just wanted to show you neighborhoods with kids, you know, it's like, no, that's steering. ECOA, and we have discriminatory protection laws there as well. We have race, religion, color, sex, and national origin. Aren't those all under federal fair housing? Yeah, they are. But then we also throw in prohibits lenders from refusing loans to the following qualified buyers. Age. You can't discriminate against me because I'm a really old guy. So you have to lend to retired persons. Marital status, you can't deny, and there was discrimination back in the 80s against women who were divorced. Yeah, that's illegal. Public assistance, if you have public assistance income or some other form of revenue, that has to be counted and applied to your qualifying. And remember AMP, age, marital status, and public assistance, can't discriminate. Does not protect minors, a person's sexual orientation, or people with erratic employment histories. That kind of makes common sense. Sexual orientation is not a protected class under federal fair law, or under federal housing, or ECOA, and requires a lender to give notice of why credit was refused. So if the lender turns you down on a loan, they have to tell you exactly why they turned you down on the loan. They can't say, oh, it's because you wear glasses or whatever.
So that they could say no to a loan to like a lesbian couple.
Yeah, no, not really, because the only thing I can deny you on is your inability to qualify. So we have protected classes, and you need to know that. You need to know the difference between ECOA and federal fair housing, and the one, pretty much and only, is age. Is age a protected class under federal fair housing?
No.
No, it's not. Is it a protected class under ECOA, Equal Credit Opportunity Act?
Yes.
Yes.
Yes, it is.
And that includes minors with means.
Minors with means.
Mhm.
I like that term. But wait, they're a minor with means, so I go to contract, but have I created a voidable situation?
Yeah.
Yeah, so you can't discriminate, so.
Well, the lender can. All right, the Americans with Disabilities Act, ensures equal access to public accommodations for disabled persons. Public accommodations are places accessible to the public, including broker's office, retail stores. Megan's Law requires the registration of sex offenders. Brokers should inform buyers who may be concerned about a registered sex offender to contact law enforcement offices. We can't represent this, guys, but there's a webpage that shows their locations. You knew this, right? Just like there's a webpage that will take you to the police department where they can represent the crime stats, right? There's a webpage that represents the location of convicted registered sex offenders. States vary on requirements of brokers for disclosure and how to inform buyers of this law. So it becomes state specific. The obligations of the brokerage firm. Firm owns all contracts, has all agency relationships. When an associate broker leaves the firm, they can't take the contracts or listings without permission. There's a national exam question about that. And as long as you know that that listing is owned by the brokerage, not the broker. Not the listing broker, but the brokerage, you'll get the right answer. The employing broker is responsible for the following. So I'm the employing broker, I'm the responsible principal broker. Do you see all the different ways that they say the same thing? I'm the employing broker because all monies go through me. Everybody associated with me has agreed to compensation based on. And once they have fulfilled and provided me with monetary resources, then their agreement kicks in and I write them a check based on the compensation agreement between, but it goes through me. So all contracts, listings, purchase agreements, supervising all licensees under them. Role of the associate broker employed to represent the broker and brokerage. Those duties to the client equivalent to the duties owed by the employing broker. Remember, when I sign a listing, or when you sign a listing agreement for my brokerage, you're committing me. But you're also committing you, but back through sub-agency, because I become the agent for that listing. I am the principal broker of that listing. My brokerage owns it. But through sub-agency, I empower you to represent my brokerage with the seller.
Can I elaborate on this too?
Yeah.
One of the questions on the test, is like, independent contractor, what's that mean? Code name, like, I.
1099, independent contractor, employment agreement.
Anyways, they asked the question like, the brokerage name that's recorded, like, whoever's, working for that broker, they don't have a, like.
Trade name.
Trade name, there you go, that's the answer.
Yeah. You can't have a trade name as an associate broker, only I can have a trade.
The broker.
The qualifying broker, principal broker, supervising broker, I mean, how many different ways can we say the same thing? Does that make sense?
That's one of the questions that was on the.
Thank you, sir. Trade name. You know that?
I have a question on,
Only, the principal broker can establish the trade name. Associate brokers do not have trade names.
if you look at, on the roles, on the roles of salesperson, under, 2A, where it says you, set state when required, you cannot be required in the work set hours.
Uh-huh.
How does that come about? I mean, why hire you for a reason when you're just talking about brokers in general? And not.
I'm talking about brokers in general. I can't really tell you that you have to work these hours. I can't tell you that you get these days off, yeah.
Mandatory meetings.
Yeah, mandatory meetings, yeah, all that kind of stuff goes by the wayside.
Okay.
So it's kind of cool to be one of us, cause it's so free. Oh, look, I can do what I want.
So when you say employees, they're basically talking about position.
Right.
Training, you said that an associate broker cannot have a training?
Correct. You cannot register a trade name. Only the qualifying broker can. And you're looking at me because you want to do an LLC or an S corp, is that correct?
Well, my understanding was that you can have a training, you don't have to list it or publish it.
You can have an LLC, you can have a S corp, you can have a C corp, you can do a sole proprietorship, you can do anything you want. What you can't have is a trade name. Now, you can have a team name, is that a trade name? No. But my brokerage has a trade name that I, as the agent of the brokerage, registered with the commission to do brokerage business within the state of New Mexico under the trade name of my brokerage.
Yeah, I was confusing training with LLC.
Yeah.
You know.
Oh, no, I highly recommend you get an LLC or an S corp or something of that ilk for tax purposes, because you're making money. I'm not saying you shouldn't pay taxes, but you should pay no more than your fair share. However you want to define that.
And the broker pay the LLC or they have to pay?
Yep, I do all the time. I just wrote a check to an LLC for a major chunk.
Gotcha.
And the LLC will get the 1099. Ma'am?
You're gonna just tell me to ask my broker.
Yeah.
Oh, that's the broker.
I was gonna say, so my LLC, I just set up for real estate, but I do consulting on the side, and it's the same.
I don't care, you can do whatever you want. More power to you. But when it comes to representing real property for others, I am responsible for everything you do. And if consulting is part of that, I am responsible for that, and you need to run it through me.
My consulting's IT, so.
But if you're consulting for, you know, feng shui, or yin and yang, I don't know, my yin is out of balance with my yang right now. How about you?
More meds.
No more meds. I was thinking more like a break. But if you wanna take meds on break, okay. See you in 10.
But I want, I was like.
Turn my phone on.
Oh, you're good. I'll take it. How's Rhea?
Not bad, man. Too short, too short.
Whatever, I see you did it. Like, never mind, we did it. After I filmed it the first time, I like walked out, and it's like the same little person. Oh my God. It's like the same little dude that's there, and I was like, what's up, brother? I see you again. And he was like, I'm glad that your spirits are filling your chest.